Welcome to For the Record with Greenwood Law.
Welcome back to For the Record with Greenwood Law with attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level personalized representation and hands-on approach to every case. I'm Evan Mack, and today we're talking about how bond is decided in North Carolina criminal cases. Dylan Greenwood, sir, welcome back.
Appreciate it. Glad to be here.
Dylan, when a case reaches to a point where bond is being set, what is the court ultimately trying to determine in that moment?
So they're trying to determine two major things. One, safety of the community, and two, whether or not you're going to come back to court. Because really the purpose of bond is not to be preemptively punitive. The purpose of bond is to make sure that you're going to get to court. So the court is looking for some sort of security, typically via money or the threat of money being levied against you, to make sure that you're actually going to show up and be to court. Because if you're getting charges, we want to make sure that that process is going through, both for the side of, making sure that society is taking care of the criminal side of things and that the criminal justice system is working smoothly. But also the flip side of it is because you have the right to a speedy trial in this country and in the state of North Carolina. So because of that, we want to make sure that that stuff is addressed.
What information is typically in front of the magistrate or judge when that initial bond decision is made?
So it really depends, and it depends a lot as to whether or not you have an attorney or not. I can tell you that the first appearances that I have witnessed that do not involve an attorney usually go this way. Someone tries to get up there when it's their opportunity to speak to the judge, and they're trying to explain their case. They're trying to explain why they're innocent. They're trying to explain why this should have never been charged in the first place. A judge will shut that down so quick because you are probably going to say something you shouldn't say. You might make everyone in the courtroom a witness to you accidentally admitting something. You may, further incriminate yourself in some way. So usually that's not a good thing. And a lot of times what I see is that the state presents, a brief factual recitation as to what might have happened. Somebody's criminal history gets discussed. Maybe some family members are there that go, well, we need him out or need her out for this reason. They work, they do this, they take care of the kids, and we can only afford this amount of money, which is a factor, actually, what you can afford for bond. Versus going with an attorney. An attorney knows different buttons to push and factors to present and what to discuss about you, so that an actual full determination of bond can be presented. Now, if that can't happen for you because you can't get an attorney quick enough, an attorney can do that on the back end if you're still in custody via a bond motion to try to get that reduced down. But I will say it's a little more difficult at that stage versus the initial appearance aspect of it.
So how do factors, like the severity of the charge, and you talked about someone's prior record in previous episode, how's that influence the type or maybe amount of bond that is set?
There's no easy way to answer that now, especially with changes in law here in North Carolina. We've broken it down into nonviolent versus violent offenses. So for instance, if you've been charged with a violent offense, and there's a bunch of enumerated offenses in the statute, but the main ones are any A through G felony or a felony that involves potential registry on a sex offender registry. And then there's a few other ones that are littered in there. But there's a presumption there that a rebuttable presumption against pretrial release for those violent offenses. But if you're able to rebut the presumption, then they have to set secure bonds. And that becomes even harder if you've had prior violent convictions or you're currently out on another violent offense, awaiting the resolution of that case. So all those factors play in. Now, on the other side of that, if it's a nonviolent offense, then the factors that are looked at are, what's your history in the community? Have you lived here for a while? Do you have family here? Do you work? What the nature of the offense is, what the veracity of the evidence. So how strong is the evidence surrounding you? Now, if you might hear me say that and say, well, you just said somebody might present something about their case and the judge is going to shut them down. There's a difference between trying to present not guilty or evidence to exonerate at that stage versus talking about how the state's evidence lacks credibility. And those might eventually play into one another, but at the initial appearance stage, it's more important to look at the credibility of the evidence right then and there versus trying to present your case. But the other things that get looked at are your prior criminal history record. Have you ever failed to appear for court? Even for a traffic ticket, that will get taken into account. So, I mean, it's a bunch of different things that end up coming in.
So North Carolina uses different types of bond conditions. How do those, options differ, and, what determines which one is applied in any given case?
Oh, yeah. So, like I said earlier, stuff involving violent felonies, if you can actually get a bond, it's going to be a secure bond. It's almost guaranteed. It's basically guaranteed by statute now. We've done away in North Carolina with written promises. So it used to be easy to, on certain things, certain misdemeanors, even low-level felonies, if you had never been in trouble before, to just go in and get a written promise to appear to court. You wouldn't have any money hanging over you. You wouldn't have to post any money for a bond. You just say, hey, I promise I'm coming to court. Don't have that anymore. So even on low-level felonies, we've got people that are being given some form of a bond. Now, there is a huge difference in what those look like. So with an unsecured bond, you have money hanging over you. You don't have to post money to get out. You're still walking out on the street once you get an unsecured bond set. But if you fail to appear in court, all of a sudden that bond is forfeited and you owe that money to the state of North Carolina. So it's hanging over you. And I don't think a lot of people necessarily realize what that mechanism is, but in essence, that's it. The other side of that is if you have a secured bond, and that's what people a lot of times think about when they think of bond. And a secured bond, so let's say it's set at $30,000 secure bond. You're either having to post $30,000 of your own money or a friend's money, family member's money, or an amount of property that will eclipse $30,000 by a certain amount, and as a surety that you're going to come to court, and then that money or that property gets wrapped up into your bond, and that is held by the state of North Carolina until the resolution of your case. Now, if you don't ever get an order for your arrest, if you don't ever get a failure to appear, that gets released back. So that person gets all that money back, or they get their property unencumbered and back. Okay? Most people can't do that. So a lot of people go to a bondsman or a bondswoman and they get a bond through that individual, where that individual goes and posts that money for you. But for them posting that money for you, you pay them a fee. And that fee is typically between 10 and 15%. A little caveat to that is if you are a certain individual that a bondsman or bondswoman considers to be high risk, like high risk of flight, then they can elect not to give you a bond. They don't have to post that. Or you have certain bondsmen that specialize in high risk bonds, and they might ask you to post on the 15% side of things versus the 10%, or they work with certain agencies that back the bond, so that we know, especially on really, really high level bonds, like $250,000 and above, or somebody that maybe has ties to another country. That's a potential high-risk bond because there's a higher risk of flight. Because if you don't show to court, then that bondsman is on the hook for that money getting released to the state of North Carolina, not that individual anymore. So they need to know that you're going to court and that their money isn't going to get released to the state of North Carolina.
What about this though? What role do prosecutors play in bond decisions, particularly in more serious cases?
So they're there to present your criminal history, first and foremost, typically. And again, we've changed the rules here in North Carolina. It's not just criminal convictions anymore. It's your entire criminal history.
Wow.
So, and that includes all the things you were charged with. Did it have a failure to appear associated with it? Did it have order for arrest associated with it? Doesn't matter if it was dismissed, not guilty, whatever. Everything's presented now. They're also there to, again, present some sort of brief factual basis for why they're there in the first place. And they're there to argue for bond to be at a certain amount. And it's typically higher than what you're thinking it should be. Now, that's not always the case. There are times that if we get involved in a case early enough and we're reaching out to a district attorney, we could mutually agree on a bond. And that way we're avoiding the whole back and forth of a bond hearing, at least in the way that I'm describing. And you just walk in there and say, all the parties agree that the bond should be set at $10,000. Mm-hmm. And you know that because, your client or your family says, hey, I can post this amount of money. Maybe there's some discrepancies in the evidence that all sides can see to begin with. Maybe, somebody just has no criminal history whatsoever, and everybody can say, hey, yeah, this bond makes sense for this person. And then sometimes a DA will do that with you because of the nature of the case relative to the judge you're going to go in front of, and you're better off agreeing to something ahead of time relative to leaving it in the hands of someone else to decide.
So once the bond is set, though, what does it take to revisit or modify? How does that process typically unfold, if that's possible?
If you have a first appearance and there was no attorney involved, when that attorney gets involved in your case, if they do, they probably have the ability to go ask for bond to be reconsidered. Because that's a change in circumstance of the case. You've got an attorney involved that's usually dug up some stuff. Otherwise, there has to be some sort of significant change of circumstance or events surrounding the case. Either new evidence has come to light one way or the other on the matter. Either you've figured out there's some sort of evidence that's exculpatory in nature that can help you out, and you're presenting it and saying, hey, we need this. It might be a personal circumstance that comes about. Let's say somebody's a family member's dying, or childcare becomes a significant issue because, let's say, like a spouse has passed away and a child is left in that set of circumstances. Sometimes that can be a reason. That's a significant change of circumstance that's very personal in nature that could be a reason for modifying bond. Another reason is because, let's say you have waited around and waited around and waited around for any semblance of discovery or report to come available, and it's been months and there is nothing. I've seen that happen a few times where you go, hey, we don't have anything. Are they really, trying to prosecute this fully or with any kind of speed or, efficiency here? If they're going to drag their heels, then my client needs to get out. And that's the gist of the argument right there. And I mean, that certainly gets paid attention to. So the other thing that could change, people's, financial circumstances, every bit of that. If you can find something of substance that a judge can hold on to, then you could probably bring up a bond motion.
So how do bond decisions early in the case start to influence the direction or strategy as things move forward, Don?
There's two sides to this coin. In theory, when somebody is in custody, one, not in theory, you know where they are, and you know that they're going to come to court. So you don't have to worry about that. Like, from my perspective, from the court's perspective, they're going to come to court. In theory, this is the theoretical part, they're out of trouble by being incarcerated or being detained. And that can be a concern for certain individuals who seem to have the inability to stay out of trouble. Even maybe it's because of the people they hang out with. And I can tell you right now, that's a concern for younger people. Like you've got people 20 years of age, maybe a little bit younger, maybe a little bit older, that seem to be hanging in with the wrong crowd. Maybe they're not doing anything just super, super serious, but maybe they're just kind of collecting drug charges or something like that. There's an argument to be made that maybe they're better off detained because they, in theory, shouldn't be around drugs, in that circumstance. I can tell you that that is not always the case in a detention center, nor is it always the case where they're out of trouble by being in a detention center, because the detention center offers the ability for somebody to meet new contacts, and then that starts its own set of issues. So there's a bunch of different things that play into that. The main thing, or the main argument from the defense perspective of why you want somebody out, is that it is a lot easier typically for them to help in the defense of their case if they're out of custody versus in custody. They can get you records easier. They can come and meet with you easier. They can help you go through pieces of discovery easier. It is one thing to have my eyes to look through them, and it's certainly a benefit to have an independent viewer like me to look at discovery. But at the same time, there's a benefit to you as the defendant to be able to look at messages, certain things where you know what you're looking for because of the circumstance, or somebody better, or a witness, or whatever it may be, and you're like, oh, here's actually something you really need to key on about the situation or about this person, and that can really help. So helping in the defense is a big aspect of that.
And finally, Dylan, when you're evaluating a case early on, what signs suggest that a bond decision, may, change as more information comes to light?
That typically pans out in cases where we suspect that there's a potential alibi. So we're waiting on surveillance camera footage based off subpoenas we've served, maybe cell phone location data. We've been able to use that successfully as an alibi. To where we've been able to show that, like, our client is either on a phone call or sending a text message. It pings off of a certain tower, and that tower is an hour away from where this other stuff was alleged to have occurred. And that stuff takes a while to get back, and that it takes a little bit of time to comb through. So things like that, where you're trying to procure records. The other thing that can affect this, all of a sudden, the availability or the unavailability of witnesses, that may shake itself out during that time period in a way that it affects bond as well. So basically, it comes down to availability of pieces of evidence, or the procurement of new evidence that sheds a different light on what's occurring.
Dylan, appreciate the time, brother.
You got it.
All right, that's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening, and don't forget to leave a review, and share this episode with someone who might need it as well. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.